By the time I walked into the Franklin County courtroom, my own son had already turned my right to control my money, my company shares, and my life into a question for a judge. The bailiff's shoes clicked against the tile. The folder under my palm felt rough where the cardboard edge had split, and the room smelled faintly of burnt coffee and lemon, cleaner. Melissa saw me first. My daughter-in-law leaned toward her attorney and laughed. Not loudly. That would have been crude. Melissa never wasted a knife when a needle would do. Brian looked at me once, then turned his face toward the seal behind the bench. I took my seat, beside Evelyn Shaw. "Don't answer anything nobody asks you," Evelyn murmured. "I spent 30 years following money through lies," I said. "I can manage a status hearing." Her pen stopped. "Thomas, that sentence. This is exactly why I told you not to improvise." Fair enough. I was 63 years old, and before retirement, I had worked as a forensic accountant. I had testified about forged checks, hidden accounts, sham, vendors, and families who discovered too late that trust was not an internal control. Yet, on that August morning, the papers across the aisle described me as a man who forgot bills, misplaced his car, confused appointments, signed things he didn't understand, and needed his 36-year-old son to manage his estate. The clerk called the case. Judge Arthur Bell entered, and everyone stood. Paper shifted. A chair leg scraped behind me. When Bell sat, he glanced down at the file, then toward counsel. Then he saw me. His hand stopped above the page. "My God," he said quietly. "Is that really him?" Melissa's smile disappeared. Bell adjusted his glasses. "Mr. Reed?" "Yes, Your Honor." He stared another second, then looked toward the attorneys. "For the record, I recognize Mr. Reed from a Nalderman financial exploitation prosecution approximately 20 years ago. I was an assistant county prosecutor. Mr. Reed served as a forensic accounting expert. We had no personal relationship then or since." Evelyn rose. "No. Objection from Mr. Reed." Melissa's attorney conferred with her and Brian before saying they had none either. Bell nodded. "Then we proceed." That was all. No secret alliance. No rescue. The judge, who I remembered what I used to do, was about to hear my family argue that I could no longer manage a checking account. Melissa's attorney began, carefully. "This was not," he said, "about punishment. It was about protection. Brian was asking the court to determine whether I needed a guardian of my person, my estate, or both. If the court found that level of protection necessary, Brian wanted to be appointed guardian of my estate. Protection. The word landed softly enough. Then came the examples. An electric bill I had supposedly forgotten, a medical appointment I had missed, my car found on the wrong level of a parking garage, text messages that, printed alone, looked confused, a clinician's preliminary report recommending further evaluation. Melissa folded her hands while her attorney spoke. Her wedding ring caught the overhead light every time she shifted her fingers. When Bell asked whether she understood that no final finding would be made that morning, Melissa nodded. "Of course, Your Honor. We just don't want something terrible to happen while everyone is waiting." Everyone. As if I were the only person in the room capable of causing damage. Brian was asked whether he supported the petition. My son cleared his throat. "I do," Bell asked. "And you're requesting appointment over your father's financial estate if the statutory requirements are met?" "Yes, sir." He still didn't look at me. Evelyn touched one page in front of me. A screenshot. I recognized my own words immediately. "Fine. Put it wherever you think it belongs. I already told you I don't remember doing that." Standing alone, it sounded bad. The line above it was missing. I leaned closer. Evelyn whispered, "What?" There was a question before that. "What question?" I searched my memory and found only the shape of the conversation, not the exact words. Melissa had been helping with household accounts after Ellen died. Shared calendars, online bills, password resets. Things my wife and I had divided between, get us for 37 years, until cancer turned our kitchen counter into a pharmacy and then left one chair empty. I need the full thread. I said. Evelyn wrote 3 words on her pad. Get full export. Across the aisle. Melissa watched us. Her attorney continued explaining that the petition included supporting exhibits and that both sides would need time for discovery before the evidentiary hearing. Judge Bell set dates. He explained what would and would not be decided. His tone stayed flat, procedural. Good. I didn't need a favor from a man who remembered me. I needed the record to stop lying. At one point, Melissa's attorney referred again to my increasing suspicion when family members attempted to correct him. My fingers tightened around the folder. Evelyn laid 2 fingers on its edge. Not now. So I said nothing. That silence cost more than I expected. For months, Brian had answered my questions with the same patient tone people use when repeating directions to a stranger. Dad, we already do. Discuss that. Dad, Melissa fixed it for you. Dad, you left the car. There. Dad, you asked us to handle this. Each sentence was small, enough to swallow. Sitting in court, I finally heard what they sounded like together. Judge Bell scheduled the main evidentiary hearing for August 17th. The shareholder vote at Reed Precision was set for August 28th, 11 days later, although nobody in court had said the company's name yet. I wasn't ready to say it either. Not until I knew whether I was chasing a pattern or hiding from something simpler. The clerk announced the next matter. Chairs moved. Melissa stood, smoothed the front of her jacket. As we filed into the hallway, she came, close enough that I caught the clean floral scent she had worn to. Ellen's funeral. Thomas, she said, lowering her voice. This can still be easy. I looked at her. For who? A tiny pause. For everyone. Brian was several feet behind her, staring at his phone. I called his name. He looked up. Did you read every exhibit before you signed that petition? His jaw shifted. Dad, not here. That's not an answer. Melissa stepped between the question and my son without physically moving between us. She only turned her shoulder. You see, she said to Brian, this is what I mean. Brian slipped his phone into his pocket. Please don't make today worse. Evelyn came out of the courtroom carrying her briefcase. Thomas, 1 word. Enough. I walked away before I gave Melissa another sentence to print. In the elevator, the motor hummed. Above us. Evelyn waited until the doors closed. You recognized something in that screenshot. The missing line. Can you prove it? Not yet. Then right now it's a memory dispute. I rubbed the worn corner of my folder with my thumb. I know. Good. Because they have documents. We need documents. The elevator opened onto the lobby. That was when the electric bill came back to me. Not the accusation from court. The actual afternoon in July. I had been standing at my kitchen counter with a mug of coffee gone cold beside my elbow. The refrigerator compressor kicked on. An envelope lay open beside Ellen's old ceramic fruit bowl, and the red word overdue showed through the folded statement. I had stared at it because I remembered paying it. Not vaguely. I remembered the amount. I remembered scheduling the payment online. I remembered printing the confirmation because Ellen had spent 3 decades teasing me for keeping paper in a digital world. Brian had been in the kitchen that afternoon. He picked up the notice, read it, gave me a look I had started seeing too often. Dad, he said. I forgot again. I hadn't argued. Instead, I had opened the drawer beside the stove and found the receipt. At least, I thought I had. Standing in the courthouse lobby weeks later, I could suddenly feel that thin sheet, fold of paper between my fingers. "Evelyn," I said. She stopped. I kept the confirmation. Where? That's what I'm going to find out. Because if that payment had been scheduled the way I remembered, then one of two things was true. Either I had canceled it and forgotten, or somebody else had. Where would you put a receipt if you wanted to prove to guest? Yourself you weren't imagining it? Evelyn asked. We were standing beside her car in the courthouse garage. A horn chirped 2 rows over, and every footstep bounced off the concrete ceiling. In the kitchen? Drawer, I said, unless I moved it. Evelyn unlocked her car. That last sentence matters. I know. No, Thomas. It matters more than the receipt. Don't decide what happened before you have the record. 20 minutes later, I was pulling open the drawer beside my stove. Pens rolled against a tape measure. Ellen's old grocery coupons were still clipped together, even though half had expired before she died. No receipt. I emptied the drawer. Nothing. For several seconds, the refrigerator was the only thing making noise. Then I checked the folder where I kept utility statements. July's bill was there. The red overdue notice folded behind. With it, I sat at the kitchen table and logged into my bank. The payment history showed exactly what I remembered. I had scheduled the electric bill. Then another line appeared beneath it. Canceled. I leaned closer. The cancellation had been entered before the payment date. That didn't prove anyone had touched my account. I could have canceled it myself. Brian had limited access to help with bills after Ellen died, while Melissa had helped organize household accounts when probate paperwork covered half my dining table. I printed the page. The printer rattled and pushed out one warm sheet. Paper again. Ellen would have laughed. You know they invented folders on computers, she used to tell me. And nobody ever spilled coffee on a filing cabinet and deleted 6 years of records. My phone rang. Brian. Dad, my son said when I answered. Melissa told me what happened in the hallway. What? He happened? You questioning everybody. I asked whether you read what you signed. You cornered us outside a courtroom. You were already outside the courtroom. Brian exhaled. You know what I mean. I looked at the canceled payment. Do you remember the electric bill in July? Which one? The overdue notice. Yeah. You forgot to pay it. The bank says I scheduled it. That doesn't mean it went through. It was canceled. His voice softened. Okay. Did you cancel it? No. Quick. Answer. Did Melissa? Dad. I don't know. Maybe you asked one of us to fix something. There were duplicate payments around then. That's what Melissa said. Because that's probably what happened. Probably. I wrote the word in the margin. Brian heard the pen scratch. Are you, taking notes? I used to do that for a living. You're not. Investigating a company. No. I'm asking about my electric bill. Silence. Then my son said, This is exactly why we're worried. He hung up before I could ask what exactly meant. A canceled payment wasn't proof of a scheme. Neither was an irritated son. So I did what I had done when numbers refused to tell a clean story. I stopped asking them to agree with me. I started recording what they did. First, access. After Ellen's death, Melissa had offered to manage our shared family calendar because medical appointments, probate meetings, and company calls kept colliding. Brian had limited access to online bill pay. I had approved both arrangements. That mattered. If you give someone a key, you can't later act shocked that they were able to open the door. The question is, what happened? Afterward, I photographed the calendar on my laptop and phone with the date and time visible. I wrote down the mileage on my Buick. Receipts went into an envelope instead of the kitchen drawer. Then I mailed myself a certified letter containing a page with 3 appointments, 2 bill payments, And the mileage. The postal clerk pushed the receipt toward me. Keep this. I intend to. For several days, nothing happened. That was almost worse. I noticed every ordinary mistake. Reading glasses beside the washing machine. A coffee mug left in the wrath den. One evening, I spent 15 minutes searching for my house keys. They were in my jacket pocket. I stood beside the coat rack with my fist closed around them. Nobody had moved those. I had. The next morning, my calendar showed a cardiology follow-up at 11:30. I wrote the time on a yellow pad beside the phone. At 10:45, Melissa called. Thomas, where are you? Home. You're supposed to be at the clinic. My appointment is 11:30. No, it's 10:30. I turned toward my laptop. The calendar now said 10:30. You changed it. A short silence. Then, Melissa said, I corrected it. When? When I noticed you had the wrong time. You didn't call me. I'm calling you now. After the CROM appointment started. A cabinet clicked on her end. Thomas, I can't do this if every correction becomes an accusation. I'm asking when you changed it. You had the wrong time. That wasn't my question. Her next words came slower. You should write this down while it's fresh. The line went dead. I already was. The photograph from the night before showed 11:30. Something had changed. A picture couldn't tell me who had done it, though. Not by itself. That afternoon I drove to Reed. Precision for a short meeting. The garage had employee access, but no assigned spaces. I parked on level 3 near the west stairwell and photographed my dashboard before getting out. Mileage, fuel, time. When I returned, the Buick wasn't there. I walked the row twice, then checked level 2. Nothing. On level 4, I found it near the elevator. Brian came through the stairwell. There you are, he said. I pointed at the Buick. Did you move it? His forehead creased. Why would I move your car? I parked on 3. Dad, you parked here. I took a picture. Of the parking space? The dashboard. So it doesn't show where you parked. He was right. That bothered me more than if he had laughed. Brian reached toward my shoulder, then stopped. Let's not turn a parking mistake into something. Through the windshield, I saw a white charging cable on the passenger seat. Brian used one like it. So did half the country. I said, nothing. At home, I compared the dashboard photograph with the odometer. 4 additional miles. Not proof. Enough to circle. 2 days later, my little system embarrassed me. I placed a blue envelope containing a hardware store receipt on the second shelf of my office bookcase. I photographed it and wrote the location in my notebook. That evening, he was gone. For one long minute, I stared at the empty shelf. Then I found the envelope on my desk beneath a property tax statement. The memory came back. Mail had arrived. I had carried several envelopes upstairs and moved the blue one myself. No Melissa. No Brian. Just me. I sat down. The notebook lay open beside my hand. Its neat lines, pretending the world could be controlled if I recorded enough of it. The following afternoon, Evelyn listened while I showed her the canceled payment, calendar photograph, mileage log, and failed envelope test. When I finished, she pushed the papers toward me. What do you think? They prove that something is wrong. That's a conclusion. I waited. Evelyn tapped the failed test. This helps. How? Because you recorded the mistake even though it hurt your theory. Traffic moved below her Broad Street window. We don't have to prove you never forget anything, she continued. We need to establish what happened, who had access, and what legal consequence Brian is asking the court to create. My life changes if he wins. Yes, but I'm asking something narrower. She pulled the petition closer. If Brian gets control over your financial estate, What decision becomes easier for him to make? My eyes dropped to the filing date, then the hearing date. For the first time, I stopped thinking about the electric bill. Reed Precision came to mind, and with it, one vote I had already told my son he would not get. The vote, I said. Evelyn didn't answer right away. She pulled the petition closer, then turned it 90 degrees. So we were both looking at the same page. What vote? The sale of Reed Precision. Her eyes moved to say this. Mine. How much of the voting stock do you control? 36%. And what does the deal require? 2/3 approval. That changed her posture. Not dramatically. Evelyn Shaw did very little. Dramatically. When is the shareholder vote? August 28th. She looked at the calendar on her desk, then at the petition filing date. That gives us a timing problem. Or a timing answer. Don't get ahead of the documents. I almost smiled. For the next hour, she made me explain the company from the beginning. Not the sentimental version, families tell at funerals, but the legal one. Ownership, voting rights, board authority, shareholder agreement, what Ellen had owned, what transferred to me after probate closed in April, what Brian owned, himself. 36% sat in my name. Brian held 18%. The rest was split among smaller family holders and an employee trust. The proposed sale needed at least 2/3 of the voting power. Without my shares, it could not pass. That's not the same as saying Brian gets your vote if you lose this case, Evelyn said. I know. I need you to know it twice. A court would have to find incapacity, appoint someone with authority over your estate, and that person would still owe fiduciary duties. Your son doesn't just get handed a pen and your shares, but he asked to be appointed. Yes, and if he gets appointed, then he has a path he does not have now. Path, that was the word. Not control, not certainty. A path. Evelyn tapped another paragraph in the petition. Here, he is not only asking the court to protect your bank accounts, he is asking for authority broad enough to manage securities and other financial interests if the court finds that necessary. So the company is inside the request. It could be. That still does not tell us why he filed. Down it. Not yet. She capped her pen. Good. Keep those words. I left Evelyn's office with a legal pad full of questions and drove to Reed Precision. The plant sat on the south side of Columbus, a low stretch of brick and steel that smelled the same as it had for decades. Cutting, oil, hot metal, coffee from the break room that could strip paint. The front office had changed. Glass walls, new furniture. Brian liked clean lines and open spaces. The shop floor had not changed nearly as much. Machines still whined behind safety shields. Forklifts beeped at blind corners. Men and women who had worked there since Brian was in grade school still nodded when I passed. One of them, Carl Jensen, lifted 2 fingers from the controls of a milling machine. You here for the circus? He called. Board meeting. Same thing. I kept walking. The acquisition packet was already waiting in the conference room. Brian arrived last. Dark suit, no tie, tablet under one arm. Dad. Brian. He took the chair across from me. For 10 minutes we discussed debt, equipment age, labor costs, and the buyer's projections. Brian knew his numbers. That mattered too. Reed Precision was not a dying company, but it was not a museum piece either. 2 production lines needed upgrades. Margins had tightened for 3 straight years. Energy costs were up. One major customer had moved part of its work overseas. The buyer was offering real money. Good money. That was why the argument had teeth. Brian slid a page toward me. They'll modernize the high-margin lines within 18 months. And the rest? They'll consolidate. Where? He touched the tablet screen instead of answering. I waited. Some work moves to Indiana, he said. How much? We don't have final numbers. How many jobs? Dad. How many? His mouth tightened. Potentially 60 to 70 positions over 2 years. The hum of the air conditioner filled the space between us. Say it plain. I told him. I just did. No. You said positions. Brian leaned back. You want me to say people lose jobs? Fine. Some people lose jobs. If we don't invest, more people could lose jobs later. That was the strongest argument he had made in months because it was not false. I looked down at the packet. You think selling is the only responsible choice. You think refusing, because you know everyone's kids and grandkids isn't a business plan. The words landed where he meant them to. I closed the packet. My vote is still no. Brian's fingers pressed flat on the bed. Table. For now. I looked at him. He gave a small shrug. You've changed your mind before. Not on this. People change. Facts change. His jaw shifted. The meeting ended without a handshake. I stayed behind. Board materials were stored in a secure portal. As a director and shareholder, I had access to the correspondence related to the sale. I opened the thread from late June and searched Brian's name. Most of it was ordinary. Diligence schedules, valuation questions, requests for updated forecasts. Then one subject line stopped me. Voting. Authority in the event of shareholder incapacity. The email was not private advice to Brian. It had gone to the corporate counsel group and copied the board secretary. I was on the thread because the question involved voting procedures generally. I had not noticed it in June. Back then, there had been dozens of emails a day. Now the date mattered. Brian had written, if a shareholder is temporarily or permanently unable to exercise voting rights, what process governs who can act on those shares? Corporate counsel answered carefully. Court authority would matter. Existing estate documents would matter. Fiduciary obligations would matter. No automatic transfer of voting power occurred, merely because a shareholder was ill. I read the message twice. Then I checked the date. June 24th. My conversation with Brian about my memory had happened after the 4th of July. I knew because Melissa had brought over blueberry pie from a cookout, and Brian had found a credit card statement on my desk. Dad, you paid this twice. I had not. One charge had still been pending. That was the first time he said, we need to start watching this stuff. June 24th came before that. I printed the email. The page was warm when it slid into my hand. A door opened behind me. Brian stood there. You're still here. I'm reading. About what? I held the sheet at my side. Voting procedures. His face did not change much. That almost made it worse. Why? Because you asked counsel about incapacity in June. Brian walked into the room and closed the door. It was part of transaction planning. Was it? Yes. You were worried about my vote before you were worried about my bid. Memory. That's not what that says. I know what it says. Then stop, pretending it says more. His voice stayed low. Mine did too. When did you first think I couldn't handle my finances? Brian looked toward the glass wall. I don't remember the exact day. Try. Dad, this is pointless. Try. He rubbed his thumb along the edge of his tablet. Melissa noticed things before I did. What things? Bills. Appointments. Repeating yourself. Before June 24th? A pause. I don't know. You just said she noticed before you did. That doesn't mean I have a date. No. It means you have a sequence. His eyes came back to me. You're doing that thing where you turn a family conversation into an abduct audit. You turned a family concern into a court petition. For the first time. His voice sharpened. Because you wouldn't listen. 2. What? That things are changing. I folded the email once. Something is. Brian opened the door. We have a company to save. I watched him leave. Then I sat back down and opened my notebook. On one line I wrote, the date. Brian asked corporate counsel how an incapacitated the shareholders' voting rights could be exercised. On another, I wrote the date my son first told me he was worried about my mind. The first date came before the second, and for the first time since the petition arrived, the order of events bothered me more than any missing bill. The first evaluator asked me what day it was. I answered Tuesday. It was Wednesday. The clock on the wall ticked once before I corrected myself, and the sound seemed louder than it had any right to be. Wednesday, I said. Sorry. Dr. Laura Bennett made a note on the form in front of Anne. Nothing in her face changed. That almost made it worse. The office smelled like printer paper and stale peppermint. A small air vent rattled above the bookshelf every few seconds, and the vinyl arm of my chair stuck to my wrist when I shifted. Brian sat across the room. Melissa was beside him. I had agreed to the appointment weeks earlier, before the petition, when they framed it as a simple checkup after everything that had happened since Ellen died. Just to rule things out, Brian had said. Melissa had added, nobody's trying to take anything from you. Now, the woman holding the clipboard asked me to repeat 3 words. River, candle, green. I repeated them. Then came questions about bills, medication, appointments, property, company, decisions, and what I would do if someone offered to buy an asset for far less than its market value. Those were easier. Numbers had always behaved better than people. Dr. Bennett asked, if you had 2 checking accounts, and one contained enough money to cover 6 months of expenses, what would you consider before moving all of it into an investment account? Liquidity, tax consequences, investment risk, upcoming obligations, whether the investment is appropriate for the time, horizon. Her pen moved. Melissa crossed one ankle over the other. Later, Dr. Bennett asked me to remember the 3 words. River, candle, green. Correct. Then she asked when my cardiology follow-up had been scheduled. 11:30. Brian shifted. Dr. Bennett looked at the papers in front of her. The record here says 10:30. I rubbed my thumb over the seam of the chair. That appointment was changed. By whom? I don't know. Melissa spoke from across the room. I corrected the private calendar when I saw he had the wrong time. Dr. Bennett looked toward Mrs. Reed. I'd like Mr. Reed to answer unless I ask you directly. Melissa smiled. Of course. I looked at the evaluator again. The time on my calendar changed after I wrote it down. Dr. Bennett didn't ask whether I believed Melissa had done it deliberately. She asked something harder. Have there been other times when you believed records or video objects had been changed? Yes. Brian's shoe moved against the carpet. What kinds of things? A bill payment. My car. A few calendar entries. Do you have documentation? Some. What do you mean by some? I have photographs, account records, notes. Not enough yet to say exactly what happened. Her pen stopped. That answer seemed to interest her more than if I had accused anyone. The appointment lasted over an hour. Near the end, Dr. Bennett said she was not making a diagnosis that day. She wanted additional information and recommended a more complete evaluation. Brian nodded before I did. Melissa thanked her. I said nothing until we reached the parking lot. Brian walked beside me. See? That wasn't so bad. I stopped beside my Buick. She recommended more testing. That's what these things are for. She didn't say I have dementia. No one said she did. Melissa came around the front of their SUV. Thomas, nobody is trying to label you. I looked at her. You put my calendar. Problem in a court petition. Her mouth tightened for half a second. We documented what happened. What happened according to who? Brian exhaled. Dad. There it was again. One syllable doing the work of a warning. I opened my car door. Melissa said, "This is why more testing matters. If everything is fine, then good. We all move forward. And if it isn't?" Neither of them answered quickly enough. I got in and shut the door. For 3 nights after that appointment, sleep came in pieces. At 2 in the morning, I stood in my kitchen staring at the oven clock, because I could not remember whether I had locked the back door. I checked it. Locked. 10 minutes later, I checked again. Still locked. The problem was not the door. The problem was that I had started watching myself from the outside. Every forgotten name mattered. Every misplaced pen. Every time I walked into a room and had to stop for a second to remember why I was there. At 63, those things had happened before. Now each one carried weight. One afternoon, I drove to the grocery store and sat in the parking lot after buying milk, bread, and coffee. The receipt showed the correct items. I had paid with the card I intended to use. My keys were in my pocket. Nothing had gone wrong. And still I sat there. That was when I called Evelyn. "I need the independent evaluation." Her answer came immediately. "Good. You sound relieved." "I am. That's comforting." "You don't need comfort from me, Thomas. You need clean information." "Can you arrange it?" "I can give you names of qualified professionals who aren't connected to either side. You choose." "Soon, yes." A week later, I sat across from Dr. Samuel Price in an office on the north side of Columbus. No Brian, no Melissa, no family observer taking notes. Just me. Dr. Price spent nearly 3 hours asking questions that went far beyond remembering 3 words. He asked about my daily routines, financial decisions, medication, company ownership, risks of the pending sale, what authority Brian was seeking, and what could happen if the court granted it. He gave me memory tasks, attention tasks, problem-solving exercises, and questions, designed to see whether I understood consequences rather than whether I could perform like a game show contestant. I made mistakes, a few, on one task. I lost part of a sequence and had to start again. Another time, I gave the wrong month for a company meeting before correcting myself. Dr. Price did not reassure me. That helped. When we finished, he said, "I'll prepare a written report. I won't discuss conclusions until I've reviewed everything." "How long?" "A few days." I nodded. Then he asked, "Before you leave, what worries you most about this process?" The obvious answer would have been losing control of the company. "It wasn't that I'm wrong." Dr. Price waited. I continued, "If my son and daughter-in-law are manipulating records, I need to prove, but if I'm seeing manipulation because I don't want to admit, something is changing in me. I need to know that too." He wrote something down. For once, I didn't ask what. 2 days later, Evelyn called. "The preliminary report from Bennett has been filed." I was in my study. What does it say? Not dementia. Not incapacity. It says further. Evaluation recommended. That sounds less dramatic than the petition. It is. She paused. There's also a supplemental filing from Brian's side. I sat straighter. What did they add? Evelyn read slowly. Mr. Reed increasingly denies observable decline and exhibits suspicious behavior when family members attempt to correct or assist him. I looked at the notebook on my desk. The photographs, the receipts, the dates. Every precaution I had taken could now be described as suspicion. The objection could be called denial. I said, "So if I tell them they're wrong, That becomes proof that they're right. That is what their main filing is trying to suggest. The room went very quiet. Then Evelyn said, "Which is why we stop arguing about labels." "What do we argue about?" "Facts." I closed the notebook. Dr. Price's report had not arrived yet. Until it did, I had only one certainty left. From that point forward, every mistake of mine would be real, and every mistake they claimed would have to be proven. Dr. Price called me at 8:17 on a Monday morning. "Thomas, I've finished the report." I was standing at the kitchen counter with coffee in one hand and Ellen's old blue mug drying beside the sink. The refrigerator clicked off. For a second, the house went quiet enough that I could hear the paper in my notebook shift under my palm. "And? I found no evidence that you lack the capacity to understand your financial affairs or the consequences of your decisions." I sat down. Dr. Price continued before I could speak. "That does not mean you never forget anything. It does not mean you won't make mistakes. It means the testing, interview, records, and functional history I reviewed do not support the level of impairment being alleged." The coffee had gone bitter. "Can you put that exactly in writing?" "It already is." "When can my attorney have it?" "With your authorization. Today. You have it." He paused. "One more thing. Don't turn this into proof that everyone else is lying." I wasn't planning to. That answer was too fast. I looked at the notebook. Fair enough. By 10, Evelyn had the report. By 11, she had called me into her office. She read the conclusion twice, then set the paper down. "This helps." "That's all?" "That's plenty." "You don't sound impressed." "I'm paid not to sound impressed." I leaned back. Evelyn tapped the report with one finger. "This is not a magic document. The court will look at everything. But it gives us something independent, something they didn't choose." "Exactly." Then she slid another folder across the desk. "Now we look at the records." The first was the family calendar activity log. I had used the shared account after Ellen died because Melissa said keeping medical appointments, probate meetings, company calls, and family obligations in one place would make things easier. The log showed device sessions, not names, not motives, sessions. Evelyn pointed to one entry. "Your cardiology appointment was changed from 11:30 to 10:30 at 9:12 the night before." "I know. Do you recognize the device label?" I read it. Melissa's iPad. My thumb stopped on the page. Evelyn raised a hand. Before I could say anything. "Careful. This tells us the change came from a session associated with that device. It does not prove what was in her head. It proves I didn't imagine the change." Yes, that was enough for the moment. The next page showed 2 other appointment edits from the same device session over the previous month. One had not caused any problem. The other had. A probate meeting had been shifted by 30 minutes, and Melissa later mentioned in an email that I had arrived confused about the schedule. I read that line. Again. Did she know the log existed? Most people don't think about activity logs until someone asks for them. What about the bank? Evelyn opened a second folder. The electric bill sat near the top. My online account showed I had scheduled the payment. Then a secondary, authorized login canceled it. Brian's login. The room seemed smaller. I forced myself to read the full page before speaking. Could he have done that by mistake? Yes. Could I have asked him to? Yes. Is there any record of that? Not yet. I nodded. That word again. Yet. The clean answer I wanted was not there. What I had instead was something better than certainty and worse than comfort. A pattern. Evelyn turned to another record. This one came from Reed Precision. The company used garage access logs for employee security and insurance. Brian had relied on the parking incident in the petition. So the underlying access data had become relevant. My vehicle tag entered level 3 at 8:46 that morning. At 10:19, Brian's employee badge opened, the restricted vehicle access gate. At 10:24, my car tag moved to level 4. I looked up. He moved it. The records strongly support that. He looked me in the face and said I parked there. They support that too. Something in my jaw hurt. I had been clenching it. Evelyn closed the folder. Thomas? What? Don't confront both of them at once. I wasn't going to. They were thinking about it. You don't know what I'm thinking. No. I know. What people do after they get their first clean set of records. That almost made me laugh. Almost. I took copies home. For the first time in 4 weeks, I slept 6 straight hours. When I woke, sunlight had reached the edge of Ellen's empty side of the bed. I lay there for another minute, listening to the furnace fan push air through the vents. Nothing had. He'd been fixed overnight. But one thing had changed. I no longer had to argue with myself about whether every discrepancy existed. Some of them did. The relief did not last. The next morning, I found myself staring at the same question over breakfast. If Brian moved the car, why? Not because he needed the parking space. Not because of an emergency. He had later signed a petition using that incident as an example of my decline. That was different. I called him after lunch. Can you come by? Is this about the case? It's about the calendar. He was quiet. Melissa handles the calendar. Then come alone. Brian arrived 20 minutes later. No suit this time. Khakis. Open collar. He looked younger without the boardroom clothes, which made the conversation worse. He stood in the kitchen but didn't sit. I placed one page on the table. The appointment change came from Melissa's device. Brian glanced down. Okay. She helps manage the calendar. She changed the time after I wrote it down. Maybe she corrected it. She corrected it to a time that made me miss the appointment. His mouth moved slightly before the answer came. Then it was a mistake. Did you know she changed it? I knew she was helping. That wasn't my question. Brian looked toward the back door. I kept my voice level. Did you know she changed my appointments after I had confirmed them? Not every one. The words slipped out fast. I didn't move. Brian's eyes came back to me. What does not everyone mean? It means I knew she adjusted things. Without telling me? Dad, after Mom died, you had too much going on. You didn't answer. His shoulders dropped. Melissa was trying to keep things organized. I slid the calendar page back toward myself. You said that before. Because it's true. The bank record says your login canceled my electric payment. That stopped. Only for a second. Then he rubbed the back of his neck. I probably thought it was duplicated. Probably? There were a lot of bills. And the car? Brian frowned. What about it? The garage system says, your badge opened the vehicle gate before my car moved. His face changed then. Not much. Enough. Why were you in my car? I needed to. Move it. Why? A delivery truck needed room. On level 3? Yes. Then why tell me I parked on 4? He looked at the table. I waited. A long time passed. Finally, Brian said, I didn't think it mattered. You put it in the petition. That wasn't my wording. You signed it. His head came up. You think this proves some plan? I didn't say that. You don't have to. I rested both palms on the table. No. I'm asking whether you knew Melissa was changing things. She was. Helping. Brian. What do you want me to say? The truth would save time. His mouth hardened. You always do this. Do what? Turn everything into evidence. You filed a court case against me. To protect you. From a car you moved? He stepped back. The chair legs scraped, although he had never sat. Down. Talk to your lawyer. I have. Then let her talk to mine. He turned toward the hallway. Brian. He stopped. Did you know she changed the cardiology appointment after I wrote down the original time? His hand stayed on the door frame. No answer. That silence lasted longer than any denial could have. Then he left. The front door closed with a soft click. I looked at the papers spread across the table. Dr. Price's report, the calendar log, the canceled payment, the garage record. Each one explained something small. Together, they changed something larger. For weeks, I had been asking whether my memory could be trusted. Now I had a different question. How much had my son already known? The answer came 3 days later in a text message Brian never meant me to see. Evelyn called just after lunch. I have the full message export. I was in my study, sorting the records we already had into date order, from the family thread and the related production they relied on. When they submitted those screenshots, I put down the paper in my hand. What did they leave out? Enough that I want you here before I say more. Evelyn's office smelled like coffee and warm toner when I arrived. A stack of printed messages sat on her conference table, thick enough to bend the binder clips holding it together. She pushed the first pages toward me. Start with the screenshot from the petition. I found it. My words looked exactly as they had in court. Fine. Put it wherever you think it belongs. I already told you I don't remember doing that. On the next page, the missing message appeared. Melissa had written, Thomas. I moved the old insurance statements from the dining room table into the hall cabinet. You told me last week you didn't care where I put them as long as they were out of sight. Do you want me to move them back? My answer followed. Fine. Put it wherever you think it belongs. I already told you I don't remember doing that. I read the exchange twice. Evelyn said, different meaning when you can see the question. I wasn't saying I didn't remember the insurance statements. No, I was saying I didn't remember telling her she could move them. Correct. I turned several pages. Another screenshot in the petition showed me, writing, I thought we settled this already. The line before it had been cropped. Brian had asked whether I still wanted him to cancel a duplicate lawn service payment. Nothing confused about my answer. Just annoyed. Page after page did the same thing. Not every message was distorted. That mattered. Some showed me asking the same question twice. One showed me forgetting that Melissa had already sent a contractor estimate. Real mistakes, mixed in with selected fragments that looked worse when separated from what came before. I rubbed 2 fingers over my forehead. She didn't have to invent everything. Evelyn looked at me. That's usually what makes selective records persuasive. I kept reading. The messages shifted from household details to read precision. Brian wrote more often. Numbers, timelines, shareholder materials. Then, I found the exchange Evelyn had called me in for. Melissa had written to Brian. He's not going to forgive us if this goes through over his one objection, Brian answered. Once the money hits, he'll understand. The words stayed on the page. No shouting, no threat, just one sentence. From my son explaining what he believed money could fix. Evelyn said, do not make this sentence carry more than it can. I looked up. It says enough. It says Brian expected money from the transaction to change your reaction. It does not, by itself, prove why the petition was filed. I know. Good. That was her job. Keep me inside the evidence. Mine was harder. I had to keep being his father while reading it. Memory came back from the winter after Ellen died. Brian had stood in my garage with a cardboard box of tax files under one arm. Trust me, he had said, "You don't have to carry everything yourself now." At the time, I had heard concern. Sitting in Evelyn's office, I heard the sentence differently. Not because the past had changed, because I had. I turned another page. "When was this message sent?" Evelyn pointed. "July 29th, 2 days after the petition preparation had begun." I reached for my notebook. "Thomas opposes sale. Brian asks counsel about incapacity procedure. Melissa starts making more account changes. Petition preparation begins. Then this. Once the money hits, he'll double. Understand." The sequence no longer looked like separate family arguments. Still, sequence was not proof of motive. I wrote that too. Evelyn watched me. "You're getting better at disappointing yourself. I had a good teacher. I'm expensive enough to be good." That was as close as day. She came to a joke. We spent the next hour separating what we could prove from what we could only suspect. By the time I got home, the dining room table was covered in dates. Not accusations. Dates. The distinction kept me steady. The company sale appeared on one side, the petition on the other. Household incidents fit between them like stepping stones. I could see a route. I still could not prove where it ended. My phone rang at 6. Brian. I let it ring twice before, answering. "Dad." "Brian. Evelyn sent something to my lawyer. That's generally how discovery works." He was quiet. Then, "You're trying to make private family conversations into something ugly." I didn't submit. Private family conversations as proof I was incompetent. Melissa was documenting concerns. She was cropping messages. That's your interpretation. No. The crop is visible. His breathing changed. "Do you really want every conversation we've had dragged into court? You filed the case. To help you. There it is again." "What?" "That sentence." Brian's voice hardened. "You're impossible to talk to when you get like this." "Like what?" "Like everything is a trap." I looked down at the printed message on my ROM table. "Once the money hits, he'll understand." "Did you write that?" He didn't ask which message. That told me enough to keep listening. "Yes." "Why?" "Because the sale is good for everyone." "Everyone?" "The family, the shareholders, the company, the 60 or 70 people they may cut." "We already had this argument." "No. I'm asking about you." "What? About me? What money were you talking about?" A pause. "Share value." "Your shares?" "All of ours." "My shares are not yours?" "That's not what I meant." "Then explain what you meant." He exhaled sharply. "I meant that once you saw what the deal was worth, you'd stop treating the sale like I was burning down Mom's company." I looked at Ellen's chair. "You think that's what I'm doing?" "I think you're making decisions, emotionally. And you think that makes me incompetent?" "I didn't say that." "You signed a petition saying something close enough." Brian lowered his voice. "Dad, if you want to fight the sale, fight the sale. But stop pretending nothing has changed with you." The line went quiet. I said, "Something has changed. Finally. You." He hung up. For several minutes, I sat without moving. Then I opened the folder, containing my estate planning documents. Not because I wanted revenge, because I wanted an exit. There were ways to step away from the company, resign from the board, reduce my involvement, let other shareholders decide what kind of future they wanted. For 1 hour, that sounded attractive. No hearing, no argument about appointments, no son sitting across from me pretending the car had moved itself. I could walk. The next morning, I told Evelyn. She did not react the way I expected. You can resign from a board position if you want," she said. "That doesn't dismiss the petition. I could stop fighting the transaction. That also doesn't restore what they put in the court record." I stared through her window at traffic on Broad Street. If I give them what they don't want, why continue? I don't know that they would. She folded her hands. But Thomas, this case is no longer only about a shareholder vote. They are asking a court to decide whether you can manage your own estate. Walking away from Reed Precision does not answer that. So I'm trapped. No. Her voice stayed level. You have a choice. You can narrow the conflict if that is genuinely what you want. Or you can require them to prove what they filed. I looked at the timeline between us. What happens if they testify? They commit to a version of events. And then the documents either support that version or they don't. That was the first sentence in weeks that felt clean. I thought of Melissa in court, careful and soft-spoken. Brian, looking away. The cropped texts, the canceled bill, the moved car, the email about incapacity, the message about money. One by one, none of them finished the story. Together, they were beginning to ask the same question. I closed the estate folder. I don't want them scared. Evelyn studied me. What do you want? I want them certain. Certain of what? That their story still works. Her face changed just slightly. I continued. If they believe the records can be explained, they'll explain them. And once they do, I tapped the timeline. Then they have to live with the order they put things in. Evelyn reached for her legal pad. Good. That afternoon, I stopped thinking about how to escape the hearing. For the first time, I started thinking about what would happen when Brian and Melissa had to answer the same questions, with no family kitchen, no hallway, and no opportunity to change the crime. Subject, under oath. Some of this doesn't come in today. Evelyn said it before. I had even taken my coat off. Her conference room table was covered with copies of the calendar logs, banking records, and message exports we had spent weeks collecting. A fresh legal memorandum sat on top. I pulled out a chair. Which part? The raw digital records that still need foundation. The calendar? Some of it. Not all. My fingers stopped. On the back of the chair. Meaning the court is not going to treat every screenshot, exported log, or device record as self-proving, just because we know what it means. Outside the window, a city bus groaned away from the curb. Evelyn slid the memorandum toward me. The other side challenged authentication. That challenge is not frivolous. So Melissa gets to say I imagined appointments being changed while the logs sit in a folder? No. We use what we can properly support now, and we lay foundation for the rest. That sounds like losing slowly. It sounds like practicing law. I sat. Evelyn's voice stayed even. Thomas, evidence is not stronger because you're angry about having it delayed. I'm not angry. She gave me a look. All right. I'm not useful when I'm angry. That I'll accept. The ruling was narrow. Records directly certified by the bank were fine. So was Dr. Price's report. Other digital material needed clearer testimony or certification, connecting particular records to particular systems and users. Nothing had disappeared. It simply wasn't all ready. That distinction mattered, less to me than it did to Evelyn. Melissa noticed immediately. I knew, because an hour later, a message arrived from her. Thomas, perhaps this is a good time to stop escalating things that were never sinister to begin with. We were helping you. That hasn't changed. No greeting. No question about how I was doing. Just the word helping again. I forwarded the message to Evelyn and did not answer. That afternoon, I went to Reed Precision for a scheduled board review of transaction materials. The conference room smelled faintly of machine oil, even 4 floors above the shop floor. Someone had left the inner door open, and every few minutes, the distant whine of a cutting machine rose through the building. The acquisition packet had grown thicker. Financial forecasts, customer concentration analysis, environmental review, transition, schedules, employee retention planning. I had seen most of it before. One line near the back made me stop. Certain management personnel may be retained following closing to support operational transition and integration. Ordinary language. Almost boring. I read it again. Brian was president of operations. A buyer keeping him temporarily after closing would make sense. There was nothing improper about that, not by itself, but the sentence landed differently after his message to Melissa. Once the money hits, he'll understand. I turned several pages. No names. No compensation terms. No description of who qualified as certain management personnel. The independent director sitting 2 seats from me, Robert Klein, noticed I had stopped reading. Problem? He asked. Maybe nothing. That's my favorite kind. I slid the page toward him. What disclosures have we received on management retention? Robert adjusted his glasses. General transaction terms. Any individual arrangements? Not that I've seen. Brian sat at the far end of the 5 table. He looked up from his tablet. What individual arrangements? I kept my attention on Robert. If management is negotiating post-closing compensation with the buyer, the board should know before recommending a transaction. Brian leaned back. That's standard transition planning. Then disclosure should be easy. His mouth tightened slightly. We're not at final documentation. Robert looked toward corporate counsel, who had joined by phone. Are there draft retention or consulting arrangements? A short pause came over the speaker. Counsel answered, carefully. There have been discussions regarding post-closing transition services for certain individuals. Written? Robert asked. Some drafts exist. I looked at Brian. He did not look away this time. Robert said, Then I want the relevant conflict disclosures circulated. Brian tapped one finger against his tablet. We're going to delay the entire deal over preliminary compensation language? No, Robert replied. We're going to know what we're voting on. That was the first time anyone besides Evelyn had said something that made Brian go quiet. Corporate counsel explained that the materials would need to be reviewed, separated from unrelated privileged work, and produced through the board process. I asked, before the shareholder vote? Yes. Before the hearing next week? Another pause. That will depend on the review. Brian spoke, before I could. This has nothing to do with Dad's hearing. I turned toward him. I didn't say it did. You didn't have to. Robert glanced. Between us. Keep the family case out of the boardroom. Agreed. I said. Brian closed his tablet. The meeting continued, but I barely heard. The next 10 minutes. Not because I believed I had found the answer. I hadn't. The buyer might have been planning to retain Brian for 6 months at an ordinary salary. Melissa's name might not appear anywhere. The words management personnel could refer to 3 people I barely knew. Assumptions were cheap. Documents cost more. When the meeting ended, I stayed long enough to write one sentence in my notebook. Ask what exists. Do not decide what it means. That evening, Evelyn called. You requested transaction compensation disclosures? Through the board. With an independent director supporting the request? Yes. Good. You sound surprised. I'm surprised you did not call me first. I had authority to ask. That is not the same thing as strategy. It was a board meeting, Evelyn. And your son's guardianship petition is connected to a corporate sale. I waited. She continued. I'm not criticizing the request. I'm telling you to keep channels clean. Corporate production stays corporate. Court discovery stays court discovery. If something becomes relevant to the case, we Handle that through the proper procedure. I know. Good. Say it. Again. I know. Better. The next morning, corporate counsel sent a short written response to the board. Draft transition arrangements existed. Details were being assembled for conflict review. No conclusions were offered. No names were listed in the email itself. I printed it anyway. By then, paper had become less of a habit and more of a way to keep events from moving while I was looking at them. Around 3 in the afternoon, Brian called. His voice was different from the one he used when talking about my memory. Sharper. What exactly did the board ask counsel for? I was standing beside the filing cabinet in my study. Conflict disclosures. I know that. Which ones? Management retention arrangements. Why? Because management is helping negotiate the sale. That happens in every transaction. Then, the disclosure should be routine. A quiet breath came through the dock. Phone. Did you ask for my employment terms? I asked for relevant arrangements. Did you ask about Melissa? That was the first time the name entered the conversation. I did not answer quickly. Brian filled the silence. She's done communications work for the company. You know, part-time communications support, investor materials, employee announcements. I did know. I said, I asked what arrangements exist. You're fishing. No. What do you call it? Reading. His voice dropped. This is exactly what I meant before. You take ordinary things and build a case around them. You called me to ask what the board requested. Because I run operations. Then why ask whether Melissa was included? Nothing came back for several seconds. Finally, Brian said, because I don't want you dragging her into another fight. I didn't mention her. You didn't have to. He ended the call. I stayed beside the filing cabinet with the phone still in my hand. That conversation was not evidence of anything. Brian had reasons to care about transaction disclosures. He was an officer. Melissa had done company work. The board request could affect both of them without proving anything improper. Still, one fact had changed. Before the board asked for the documents, I did not know whether Melissa had any possible role in post-closing arrangements. Brian had volunteered the question himself. I wrote down his exact words while they were fresh. Did you ask? Too about Melissa? Then I closed the notebook. The court case still had its own problem. Evelyn spent the next 2 days obtaining certifications for 14, the digital records, and identifying which custodians could establish how the systems worked. No shortcuts. Melissa's attorney filed a short response arguing that household scheduling changes and bill assistance were normal caregiving activities taken out of context. That argument was not ridiculous, which made it dangerous. If every event stood alone, a judge could see a daughter-in-law changing an appointment, a son correcting a bill, a family moving a car. Helpful acts. Poorly documented, perhaps, but helpful. We still needed the order of events to matter. Late Friday afternoon, my email chimed. A notice from Transaction Counsel had been sent to the board. The conflict review was complete enough for circulation. The full management retention package would be delivered before the evidentiary hearing. I read the notice twice. No attachment yet. No compensation. Figures. No answer. Only a date. For the first time, that was enough, because Brian already knew I had asked for the documents. And now he knew I would see them before either of us testified. Melissa testified first. Her voice came through the courtroom microphone, soft and even, the same voice she used when asking whether I wanted tea after Ellen's funeral. I started helping Thomas because he was overwhelmed, she said. At first it was small things. Calendar reminders, bills, making sure he got where he needed to go. Evelyn sat beside me with one hand resting on a yellow legal pad. Across the aisle, Brian watched his wife. Judge Bell asked Melissa's attorney to continue. What happened with the cardiology appointment? Melissa folded her hands. Thomas had the wrong time. I corrected the shared calendar. Did you intend to make him miss the appointment? Of course not. Her attorney let the answer sit. Melissa continued. I was trying to prevent exactly that. The room smelled like old wood, copier toner, and somebody's coffee from the hallway. Behind me, a man coughed into his sleeve. Papers shifted at counsel table. Then Evelyn stood. Her heels made two quiet taps against the floor. Mrs. Reed, you had access to the shared family calendar? Yes. You used an iPad associated with your 9 account? Yes. And you changed the cardiology appointment from 11:30 to 10:30? Melissa glanced toward her attorney. Yes, because the later time was wrong. Evelyn lifted a certified activity log. This record shows the change was made at 9:12 the night before the appointment, correct? Melissa looked at the page. If that's what it says. It also shows Mr. Reed had already entered 11:30 earlier that day. I don't remember exactly when he entered it. Did you call him at 9:12? No. Text him? I don't recall. Leave a voicemail? No. Evelyn nodded once. So you changed the time, did not notify him that night. Then called after the appointment had already begun? Melissa's lips pressed together. I called when I realized he wasn't there. That was not an answer. Bell heard it too. He leaned slightly toward the microphone. Mrs. Reed, the question was whether you notified him when you changed it. Melissa looked at the judge. No. Evelyn returned to her table and picked up another document. Now, the electric bill. Melissa's attorney objected to foundation. Evelyn handed over the certification. The objection was withdrawn. I watched Brian. His right foot moved once beneath the table. Evelyn asked, You testified that Mr. Reed forgot to pay an electric bill. Yes. You understood that incident was included in the petition as evidence of financial decline? Yes. Were you aware he had scheduled the payment? I knew there had been some confusion. That wasn't my question. Melissa paused. I knew he thought he had scheduled it. Evelyn held up the bank record. This is the bank's audit trail. It shows the payment was scheduled from Mr. Reed's primary login. Melissa said nothing, and then canceled from a secondary authorized login belonging to Brian Reed. Brian's attorney shifted forward. Melissa looked toward my son. Brian handled some bills. Evelyn waited. The silence pushed against the walls. Did you know he canceled that payment? I don't remember. Yet you told the court Thomas forgot to pay it. I told the court what the notice showed. The overdue notice? Yes. Not the bank history? I didn't have the bank history. Evelyn's tone stayed flat. But you had access to household finances. Some of them. And you never checked? Melissa's fingers tightened around each other. We were dealing with a lot. That was the first crack. Small, but audible. Evelyn moved on. She did not celebrate. Neither did I. A single careless answer would not decide the case. The pattern had to speak for itself. Brian testified after lunch. He looked different. Behind the witness table. Smaller somehow. Not physically. Just stripped. Of the conference room. The title. The company glass walls. His attorney began with the parking incident. Did you find your father's car on a different level than he believed he had parked it? Yes. Did that concern you? It did. Why? Brian looked toward me, then away. Because it wasn't the only thing. Evelyn waited until cross-examination. Then she stood. Mr. Reed, you told your father he had parked his Buick on level 4. Yes. You signed a petition, describing that as an example of confusion. Yes. And you had access. To the company garage? Yes. Your badge opened the restricted vehicle gate shortly before the Buick moved from level 3 to level 4. Brian swallowed. Yes. Were you driving the car? I moved it. The words hit the microphone harder than I expected. Evelyn did not raise her voice. Why? There was a delivery issue. What issue? A truck needed access. Do you have a record of that delivery? I don't know. Did you tell your father you moved his vehicle? No. Why not? It didn't seem important. Evelyn looked down at the petition. Important enough to call evidence of cognitive decline? Brian stared at the table. His attorney objected that the question was argumentative. Bell sustained. Evelyn rephrased. When you signed the petition, did you disclose that you had moved the car yourself? Brian's voice was quieter. No. That one landed. Not loudly. No gasp in the courtroom. No dramatic movement. Just my son saying one word. No. Evelyn let the silence do the rest. By mid-afternoon, the full message threads came in. Because Melissa and Brian had relied on selected screenshots, the surrounding context mattered. One by one, Evelyn placed them beside the cropped versions, the insurance statements, the lawn payment, a contractor estimate. My words changed shape when the missing lines returned. Not perfect, not always clean, but ordinary. On redirect, Melissa's attorney finally found the argument they had been building toward. Mrs. Reed, families help each other with calendars, bills, and transportation all the time, don't they? Yes. Did you believe Thomas needed help? Yes. Did you ever intend to harm him? No. Did you ever intend to make him look incompetent? Melissa looked directly at the judge. No. There it was. Their safest position. Every act was care. A calendar. Correction. A canceled duplicate. A moved car. A cropped screenshot, chosen for convenience. Nothing sinister when viewed alone. Evelyn leaned toward me. This is the part where people expect too much from documents. What do you mean? They explain what happened. They don't always explain why. I looked across the aisle. Melissa sat beside Brian. Again. Her shoulders had settled. She believed the explanation could hold. Maybe it could. Judge Bell called a short recess. In the hallway, I stood near a vending machine that hummed louder than the courtroom air. Conditioner. Evelyn joined me. We have method, she said. Not motive. Correct. What if motive never comes in? Then we argue credibility, timing, and capacity. We don't invent what we don't have. I nodded. The elevator doors opened down the hall. Transaction counsel walked out, carrying a brown, expanding file. Not a surprise witness, not a rescue. I recognized him from the board process. He spoke briefly with Evelyn and handed her a certified packet that had been produced to both sides under the procedure arranged after the dime conflict review. She checked the cover sheet, then the first page. Her eyes stopped. What? Not here. Evelyn. She turned the folder so I could see only the document date. I read it. The draft had been circulated before Brian and Melissa filed the petition. My mouth went dry. What is it? A transaction conflict package. I know that. What's inside? Documents. We need to authenticate before we use them. That's not what I asked. I know. The bailiff called everyone back. Evelyn closed the file. Court resumed. She did not mention the packet. That mattered. She finished with the evidence already admitted. The judge set a continuation, so both sides would have notice and time to address the newly produced corporate materials properly. No ambush. No shortcut. Melissa looked irritated by the delay, not frightened. Brian did not look at me. When Bell adjourned for the day, chairs scraped back, and attorneys began stacking files. Evelyn waited until we were outside the courtroom. Then she handed me the cover sheet. Read the date. Again. I did. Earlier than the petition. Earlier than the supplemental allegations. Earlier than some of the household incidents they had used against me. I looked at the sealed packet in her hand. So whatever is in there existed before they asked the court for control. Yes. Does Brian know we have it? Both sides received notice. I turned toward the courtroom doors. Brian and Melissa had not come out yet. For weeks, they had explained each altered record as help. Now there was another record, one they had not created for my kitchen, my calendar, or my bank account, one tied to the sale, and it had been written before they ever asked a judge to decide whether I could manage my own life. The document was called a transition consulting agreement. Nothing dramatic in the title. No warning. No admission. Just a stack of paper with defined terms, compensation schedules, and signatures waiting at the bottom. Evelyn would not let me read it in the courthouse hallway. Not until I know exactly what has been authenticated and what remains draft material. So I wait. Yes, I've been doing a lot of that. You're still alive. That's your legal advice. It's free advice. We met the next morning in her office with the conflict package spread across the profession conference table. Transaction counsel had produced the materials to both sides, along with certifications identifying where the drafts had come from and when they had been circulated. Brian's name appeared on the first agreement. Melissa's appeared in a separate advisory arrangement. I read Brian's compensation figure twice, then a third time. It was not the kind of money a company paid someone to stay for a few weeks and explain passwords. The package described post-closing transition services, operational integration, vendor continuity, and management handoff. Brian would receive a substantial payment if the transaction closed and if he remained through the transition period. Melissa's agreement was smaller, but still far beyond casual communications work. Her role covered employee communications, integration messaging, and transition support. I looked at Evelyn. She was getting paid too, if the drafts became final and the closing occurred. Before the petition? The negotiations started before the petition. That sentence mattered more than the amount. I turned to the email chronology. There it was. A transaction message from corporate counsel to the buyer's team. We need the voting issue resolved before the meeting. Neutral words. Clean. Enough to survive a boardroom. Evelyn tapped the page. Do not read intent into this sentence by itself. I know. Say what? It proves. There was a voting issue. Yes. They wanted it resolved. Before the shareholder meeting. Yes. And compensation discussions with Brian had already started. Yes. I looked at the dates again. The room smelled faintly of toner and the peppermint gum Evelyn kept in her top drawer. What happens next? We authenticate the package through the proper custodian. Then we ask questions. The continuation hearing began 2 days later. Melissa wore navy. Brian wore charcoal. Neither looked at the file Evelyn carried. That surprised me. I had expected fear. What I saw instead was preparation. Their attorneys had the same documents. They knew what was coming. Transaction counsel testified, first, not as anyone's ally, but as the custodian who could explain the records. He confirmed the buyer had discussed post-closing arrangements with certain managers. He confirmed draft agreements had been circulated before Brian and Melissa filed the petition. He confirmed the board had not yet received the complete compensation details at that earlier stage. Evelyn asked, was Mr. Brian Reed one of the proposed transition consultants? Yes. Was Melissa Reed also included in a separate proposed advisory arrangement? Yes. Melissa's attorney objected to characterizing the documents as final. Evelyn agreed immediately. They were drafts. That took the objection away. Then she asked, were compensation discussions already underway before the petition concerning Thomas Reed's capacity was filed? Transaction counsel looked at the dates. Yes. The microphone caught. Brian's chair creaking. Evelyn moved to the email. What was the voting issue referenced here? The transaction required sufficient shareholder approval. Thomas Reed's block could prevent that approval. Was the Fruth buyer aware of the dispute over his capacity? Eventually, yes. Was the buyer directing anyone to file a guardianship action? No. Good. That mattered. The buyer was not the villain. No conspiracy spreading, conveniently beyond the family. Just a sale, a vote, and two people with a financial reason to want my vote out of the way. When Brian took the fun stand again, Evelyn began with the draft agreement. You expected compensation if the sale closed? Yes. How much? His attorney objected to relevance. Bell overruled after Evelyn tied the amount to motive. Brian gave the figure. He said it carefully, as if saying money, slowly made it smaller. Evelyn asked, when did you first learn the buyer wanted you to stay after closing? I don't remember the exact date. Before the petition? Yes. And when did you first ask corporate counsel about voting authority if a shareholder became unable to vote? Brian looked at me. June. Before you first told your father you were concerned about cognitive decline? I don't remember exactly when I first said that. Evelyn nodded. Let's use the records. She placed the June email in front of him. Then, the family messages from July. Then the petition. Filing date. Not one accusation, just order. Brian shifted. Evelyn asked, when you wrote, once the money hits, he'll understand. What money were you referring to? The value of the deal. Your consulting. Compensation? Not specifically. Your stock value? Yes. Your father's stock value? The transaction affected everyone. Did your father want to sell? No. Did he control enough voting shares to block the transaction? Yes. And did you ask a court to appoint you to manage his financial estate? Yes. His attorney stood, asked, and not yet granted. Evelyn nodded. Correct. Then she turned back to Farrand. Brian, did you know, before filing, that Melissa had changed some of her for your father's calendar entries? Brian's mouth tightened. I knew she helped with scheduling. Did you know she changed entries after your rated father had written down the original times? I knew there had been corrections. Did you know his electric payment had been scheduled before your secondary login canceled it? I thought it was duplicated. Did you check? I don't remember. Did you tell him you moved his car? No. Did you later sign a petition describing the parking incident as evidence he was confused? Yes. Evelyn's voice remained almost gentle. After Dr. Price concluded your father retained the ability to understand and manage financial decisions. Did you withdraw the petition? No. Why not? Because one evaluation doesn't erase everything. Everything meaning what? The things we had seen. The things we had seen. Calendar changes? His confusion. The bill you canceled? That wasn't intentional. The car you moved? Brian looked toward his attorney. Bell said, answer the question. My son's voice came lower. Yes. Evelyn picked up Dr. Price's report. You knew an independent evaluator found no basis to strip your father of financial decision-making authority. I knew what the report said. And you continued seeking authority over his estate. Yes. Why? Brian's fingers pressed against the witness table. Because Melissa made some things look worse than they were. The words came out before he seemed ready for them. Nothing moved for a second. Then Melissa turned to him. Not fast, just enough. Evelyn did not react. What things? Brian swallowed. The appointments, the messages she was trying to make. People take it seriously. Melissa's attorney stood. Objection. Calls. For speculation about another party's intent. Sustained, Bell said. Evelyn corrected course. What did you personally know? Brian looked at. The papers. I knew some of the examples were presented aggressively. Were they accurate? Some were. That wasn't my question. His jaw tightened. Not all of them. There it was. Not a confession. Not redemption. Just the first piece of truth my son had given me without being able to take. Ease it back. Melissa testified again after a recess. Her voice had changed. Still controlled. Sharper now. Brian wanted the petition continued, she said. He was the one responsible for the sale. Brian's attorney objected. Bell allowed limited questioning about her own actions. Evelyn asked, who prepared the chronology of Thomas's alleged incidents? I did. Who selected the screenshots? I helped. Who changed the calendar entries? I corrected them. Did Brian know? Melissa looked. He knew enough. Brian leaned toward his attorney and whispered, something. I could not hear it. I didn't need to. By then they were no longer protecting the same story. They were protecting themselves. Near the end, Evelyn returned to Brian's own email. Once the money hits, he'll understand. Then the incapacity inquiry. Then the petition. Then the independent evaluation. Then his decision to continue anyway. No, single page proved everything. Together, they left very little room. When the court finished taking evidence, Judge Bell said he would review the full record before issuing a ruling. No decision that afternoon. No applause. No punishment. Just everyone standing as he left the bench. In the hallway, Brian caught up with me. Dad. I stopped. Melissa was 20 feet behind him with her attorney. Brian lowered his voice. She pushed this further than I ever wanted. I looked at him. My hand was inside my folder. The June email sat beneath my fingers. His name. His question. His timing. I pulled the page halfway out, then stopped. Brian watched me. What? I slid it back into the folder. Nothing you haven't already signed your name to. The ruling came 4 days later. Not in a crowded courtroom. Not with reporters. Evelyn called me while I was standing in the machine shop at Reed Precision, listening to a lathe bite through steel. Thomas, she said, the petition has been denied. The machine behind me kept running. Metal curled away in silver ribbons. For several seconds, I did not answer. Evelyn continued. Judge Bell found the evidence insufficient to establish the level of incapacity Brian requested. He specifically cited Dr. Price's evaluation, the inconsistencies in the petitioner's examples, and the credibility problems created by the altered calendar entries, canceled payment, parking incident, and selective messages. I leaned one hand against the clued workbench. What about the misleading filings? The order notes. Concerns about materially incomplete or misleading submissions. It does not turn this proceeding into a criminal case. I know. Though, the court will permit the record to be provided to appropriate counsel, or authorities if further action is warranted. No handcuffs, no courtroom, spectacle, just words on paper. After months of my family turning paper against me, that felt fitting. I asked, Brian gets nothing? He does. Not receive authority over your estate. My shares? They remain yours. I looked through the safety glass toward the shop floor. A forklift beeped near receiving. Someone laughed beside a stamping press. Normal sounds. I had forgotten how much I missed normal sounds. Evelyn said, don't confuse this with everything being finished. I won't. Board review is separate. The buyer is separate. Any complaint about Evidence manipulation is separate. Understood. She paused. And, Thomas? Yes? You get to decide what you do next. That was the first sentence anyone had said to me in months that did not contain the words help, protect, concern, or capacity. I thanked her and ended the call. My phone rang again before I could put it away. Brian. I let it ring. Out. The company problem moved faster than the family problem, because the shareholder vote had a date attached to it. Without control of my 36%, Brian could not manufacture approval. The buyer knew it. So did the board. Robert Klein called an emergency governance meeting that afternoon. Corporate counsel laid out the situation without adjectives. The transition consulting arrangements, he should have been disclosed earlier and more clearly. Brian's compensation discussions created a conflict requiring review. Melissa's advisory arrangement did the same. The guardianship proceeding had raised additional questions because Brian had been seeking authority that could have affected voting control while simultaneously negotiating personal compensation tied to closing. No one said fraud. No one had to. Robert asked Brian, why wasn't the board given the full draft package before recommending the transaction? Brian looked tired. I believed the documents were preliminary. Preliminary compensation is still compensation. We weren't hiding it. Robert glanced at the production history. Then disclosure should not have required a formal request. Melissa was not in the room. She had never been a director, and her communications contract did not give her a seat at that table. Corporate counsel recommended pausing the transaction process, pending independent review. The buyer had already indicated it would not proceed on the existing timetable while governance questions remained unresolved. Brian pushed his chair back. So we're killing the deal, Robert answered. We're refusing to pretend the deal is cleaner than it is. Brian looked at me. You got what you wanted. I folded my hands. What did I want? For the sale to fail. No. You voted against it. I voted against this version. His mouth tightened. That distinction is very important to Tang. You. Yes. Because it was the difference between opposing a deal and destroying a company to punish my son. The board placed Brian on administrative leave pending review. Melissa's part-time advisory. The contract was suspended. The buyer paused the offer. Nothing happened instantly beyond that. No one lost a house. No marriage dissolved before dinner. No prosecutor burst through the door. Consequences had clocks of their own. 3 evenings later, Brian came to my house. He stood on the fine porch without knocking a second time. When I opened the door, his tie was gone and the skin beneath his eyes looked gray. Can we talk? He stepped aside. He walked into the kitchen where he had once held the overdue electric notice and told me I had forgotten. This time, neither of us sat. Brian looked at Ellen's empty chair. Melissa pushed this further than I ever agreed to. I opened the drawer beside the stove. The original succession folder was inside. I set it on the table. Brian stared at it. What's that? Before your mother died, we discussed succession, planning. He looked at me. You said the board would decide. It would. You said I was the obvious candidate. You were. He heard the past tense. I opened the folder. Inside was an old memorandum prepared during estate and management planning. Not a binding promise. Not a transfer of ownership. A plan. Brian's name appeared first among the people Ellen and I expected to consider for senior management. Succession. Another document described the possibility that part of my estate would eventually pass voting interests to him, subject to whatever planning remained appropriate. Brian touched the edge of the plan. Paige, you were going to leave this to me. Some of it. His voice rose. Then why fight me over the sale? Because it was still mine to decide. You would have given it to me anyway. Later. That's the same result. No. The word came out quietly. Brian looked at me. You. I really believe that? I believe ownership before death and inheritance. After death are not the same thing. His jaw flexed. This was about timing. This was about you deciding my consent was an inconvenience. He turned away. I took the June email from the folder. You asked counsel how an incapacitated shareholder's vote could be controlled before you told me you were worried about my mind. Brian rubbed both hands over his face. Melissa noticed things. You moved my car. That was stupid. You canceled my payment. I thought it was duplicated. You signed the petition. He looked at me again. She made the case look stronger than it was. And you knew. Not all of it. Enough. That stopped him. The kitchen clock clicked above the refrigerator. Brian lowered his voice. Dad, I thought once the deal closed, you'd calm down. You'd see the value. Everybody would have money. The company would be safe. I looked at him. And then? What? Then I forgive you? He said nothing. I closed the succession folder. Brian's eyes dropped to it. What happens to my shares? I kept one hand on the cover. My shares. He flinched. That's not what I meant. It's the part you never understood. For a moment, he looked much younger than 36. Then his face hardened again. So that's it. No. I opened the folder once more and pointed to the old succession memorandum. That was it. His name sat at the top of the page. I closed it. He left without asking whether he could come back. The board review took weeks, not days. Brian remained off management duties. Melissa's advisory work stayed suspended while counsel reviewed what had been disclosed, when, and to whom. The buyer never restored the original offer. Reed Precision still had problems. Old equipment did not become new because my son lost a court case. Margins did not improve because Melissa's screenshots fell apart. We still needed capital. Still needed a future. So I proposed something less dramatic than revenge and harder than revenge. Professional management. Independent review of strategic alternatives. A profit participation structure for employees. If the company met agreed targets. Not a giveaway. Not charity. A way to make sure the people turning steel into parts were not invisible when ownership discussed value. Robert asked me during one board meeting, "Is this about Brian?" No. Good. It's about making sure the next person in my chair doesn't confuse family with entitlement. Robert nodded. Once. That was enough. Weeks later, I stood behind the glass overlooking the shop floor, while employees gathered around supervisors discussing the first draft of the participation plan. Nothing was final. It would take months, maybe longer. Brian appeared at the far end of the hallway. He had come for a meeting with board counsel. He stopped when he saw the crowd below. So they get what I was supposed to get? I looked at him. No. His mouth tightened. Then what do they get? A chance to earn something that isn't theirs yet. Brian stared through the glass. I watched him understand the sentence. Then I walked away before he could ask me to explain it. What happened to Thomas is a reminder that help stops being help the moment it takes away your right to choose. Your children may worry about you. Your spouse may notice that you forget an appointment or misplace a document. Family members may genuinely believe they know what is best. But concern does not give anyone permission to manipulate the facts, manufacture confusion, or turn ordinary mistakes into a weapon for gaining control over your property and decisions. You should also remember that getting older does not require you to prove that you are perfect. You can forget a date. You can leave your keys in the wrong its place. You can make a bad financial decision. None of those things automatically means you are incapable of managing your own life. Thomas became stronger when he stopped trying to prove that he never made mistakes. Instead, he separated the mistakes that were genuinely his from the incidents that had been altered around him. That distinction protected his credibility. There is another practical lesson here. When something important begins to feel inconsistent, document facts before making accusations. Save the original messages. Keep financial records. Write down dates. Preserve complete conversations instead of isolated screenshots. Use independent professionals when your health or capacity is being questioned. Most importantly, do not alter evidence to make your own position look stronger. A truthful record can survive scrutiny. A manufactured story becomes harder to maintain every time another document appears. Thomas also learned something painful about family loyalty. Loving your children does not mean surrendering your boundaries to them. Brian expected to inherit part of what his parents had built, and somewhere along the way, expectation became entitlement. That difference matters. Something you may receive someday is not something you own today. A future inheritance does not give you the right to control a living parent's money, property, business, or choices. And if someone betrays you, revenge does not have to mean destroying that person. Thomas did something more powerful. He refused to protect Brian from the two consequences of Brian's own decisions. He did not invent evidence. He did not ruin the company to hurt his son. He let the documents speak, kept his ownership rights, and allowed independent processes to determine what happened next. Sometimes the most satisfying consequence is simply removing the protection that allowed bad behavior to continue. There is one final question worth carrying with you. If someone you loved told other people that you could no longer be trusted with your own decisions, how would you respond? Would you become angry and give them more material to use against you? Or could you slow down, document what happened, seek independent help, and make them prove their claims? And what if the person doing it were your own child? Would you forgive them because they were family? Or would there be a point where protecting your dignity had to come first? If you have ever experienced a moment when help from someone close to you began to feel more like control, share what happened and what finally made you recognize the difference. Your experience may help someone else notice a boundary they have been afraid to defend.